Hi everyone, and welcome to today's webinar where we'll be talking about designing versus negotiating contracts. My name is Roisin Noonan. I'm the COO here at the Law Boutique and co-founder of the oneNDA initiative. And I'll obviously allow Electra to introduce herself.
Hi, I'm Electra. I'm the founder and CEO of the Law Boutique, and I'm also the co-founder of the oneNDA initiative.
So we normally have a panel discussion, but given that we're both in the same office, we wanted to sort of run this a bit more like a conversational podcast style webinar. So we're going to be chatting for about 30 minutes and then leave about 15 minutes for questions at the end. So please get involved, be putting your questions in the chat. Maybe we'll do them whilst we're having our conversation or leave some time at the end as well. So what are we talking about today? So we're talking about designing versus negotiating contracts. And what we mean by that is rather than going head to head immediately when you start negotiating contracts, starting from a place of collaboration and designing that contract with the counterparty to be able to get the negotiation over and done with in a much more quicker, efficient way. So why is this important? So why is it that we're talking about this? The current process, how we negotiate at the moment, doesn't really work, and how we build contracts doesn't really work. So Electra, it'd be good to hear from you about what the current process is and what you see the problems are in that.
Yeah, I've been a lawyer for about 12 years now, and I've always been in the contract space. So I started off my career as a contract manager / legal manager, and contracts they've been the lifeblood of everything that I've done. And I never understood why we started from a position where the other side sends you their terms. They're going to be pro them. So you start off reviewing this agreement and it's obviously one-sided, or pretty much one-sided. It's not always the case, but often it is. It's kind of one-sided. And then you start reviewing it and you go through the standard sort of clauses and you look at them, and then you get to the boilerplate bit at the end. By that time, your eyes are glazing slightly because you're not fully engaged with what the severance clause says, are you, or what the entire agreement says. And actually you shouldn't be, but you're always feeling a bit guilty if you're not reading it in detail. And it's just all very inefficient. Plus, it starts off in an adversarial way. So the other side sent it to you. As soon as you get it, you're immediately on the defense. And you could even be on the offense as well, because you're reading the agreement, you're thinking, oh God, I hope they haven't snuck anything in that I should be aware of. So you've got this psyche when you're reviewing a contract, which is, I need to make sure that I catch any gaps. And then you're doing that and you're sending it to the other side with some red lines. You might have some punchy responses and comments saying, this is unacceptable. So you're starting off a commercial relationship. And I think that often people forget that the purpose of a contract, especially in a business context, is to form a partnership with a third party with the view that it's going to be a successful partnership. Otherwise, what's the point? And the very beginning of that partnership is adversarial in context.
Yeah, and even before you get to the contract to the other side, so the other side receives it and assumes that the contract that you've received from the other side is like, what is the position that they want to take? But actually, even before you get that contract to the other side, the person over here, so I remember working in law firms and being like, okay, we've got this deal, now we've got this deal. You're sort of cobbling together stuff from different deals to make it work, and you're not totally convinced that what you've written works. I mean, because you've been up till 2 a.m. repeatedly and you've been looking at the same contract over and over again. I think this kind of works. You send it to the other side and you have to stand by it as if your life depends on it because of this adversarial nature. It's not sort of, we're going to work together to get to a collaborative point. It's like, nope, that's absolutely perfect what I put together there, at 4 a.m.
Well, if you're in private practice, that probably happens quite a lot. And I think that as an in-house lawyer, you just send over your terms. You don't always sit and tailor each time whether your terms suit this specific client. You just say, these are my terms, please accept them as they are, because I don't want to spend time revising them or reviewing your comments. And by the way, our position is that we don't negotiate. That's not very collaborative. So if you think about it, and what I've always thought was a bit weird was that the commercial people in a business build all these relationships with the other side. They're trying really hard to make sure that they're all on the same page so that the project can succeed. And then as soon as the lawyers get involved, it just goes a little bit south.
Yeah.
Because you get the agreement and you look at the agreement and you almost feel offended by some of the things in there. There's an emotional response to some of the stuff that you see and you go, how dare you ask me that? Or as if I'm going to accept that. So you immediately get the red pen out. So you're correcting their work. And that adversarial context is actually really, Kavisha's just popped in, that adversarial context is actually not great. It's not conducive to any kind of successful partnership. Sorry, Kavisha's trying to join the webinar and she joined with the team one and appeared.
So why is that? It's kind of because we are applying words over something where we haven't thought about what the thing is underneath that's functional, if that makes sense.
Yeah.
So how would we do it differently? And are we looking at things in the right way, or are we just doing things we've always done, things in the way we've always done it, applying words over actually something that's has a purpose underneath it?
Yeah. I think we
That's
need to
super vague.
No, but I get what you mean. I think we just need to take a bit of a historical view of this. So back in the Roman times, we only wrote things down if they were really important. So a contract, a legal agreement was really important. So people took the time to get the quill out and write down what the contract was between two parties. Then we got word processors and laptops and computers. And instead of thinking, oh, we've got this technology now, maybe we should rethink how we enter into agreements with the other side and articulate our rights and obligations. But maybe we can use this technology to enable us to adhere to those rights and obligations. Instead of doing that, what we did is we just replicated the quill and paper and put it onto a word processor. And a contract that was 1 or 2 pages is now 150 pages because it's just so easy. Technology has enabled a problem, right? We've taken this paper, we've put it onto a digital form, but effectively contracts are still dealt with as static artifacts. You get your contract, you review it, you agree, you sign it off, put it in the drawer, don't really do much else with it until there's a dispute or until someone wants to terminate. You pull it back out of the drawer or your SharePoint and you look at the clause that matters and then you give advice. And it's just, there's so much work that goes into creating a contract that both parties agree to and almost very little ROI thereafter. So after a document's executed, it's not really adding any value until you need to fall back on it.
Yeah.
So you're not really getting the value other than an insurance policy. So should you just go and get an insurance policy and do away with the contract? Obviously, that's quite a flippant comment to make.
No, but it's not really. And it's when people send over a contract that's completely unbalanced, it's like, what is actually the purpose of this contract? Is it A, to make sure that you're covered for every conceivable risk? In which case, do you even need a contract? Go get an insurance policy. Or is it to facilitate this relationship operationally? And so often contracts are so sort of like taken off the shelf and just flung over. It doesn't reflect what's going on in the ground operationally, and it does just sit in a drawer. And actually, you can set really clear milestones in a contract for whatever it is that needs to be delivered. And that is when you see contracts going wrong from personal experience. Always, yes, it's because whatever you've written in the contract, people are like, what is, I know, it doesn't reflect what's going on.
I know. And the reason it doesn't reflect what's going on is because the way we do contracts is just so artisanal. I have a preference for the way we articulate this clause, and I'm going to make these little tweaks to this clause that's quite standard because that makes me feel better, or because my boss in the law firm that I worked with liked it that way, and that's how I've been taught. There is no standardization within the industry. So we talk about this a lot. When we go out on a Friday night, sometimes this is the main topic of conversation, which might sound a bit sad, but we're a bit obsessed with this. And we're thinking of a world whereby you enter into a commercial relationship with the other side. Your commercial people have said, right, guys, let's get involved. This is what we've agreed. And can you make sure that that's reflected in the agreement, in the contract? So imagine if you were to enter into a meeting with the other side, and instead of going, right, here's my terms, you review them, tell me what you can and can't accept, you went, right, what are we trying to achieve here? Let's pick from this menu of clauses that we've all agreed to, by the way. So let's not worry about the drafting, because the wording is almost like the code. If we translate this into software world, it's like the code that supports the function. So let's not worry about that code. Let's not worry about the legal drafting. Let's just worry about what the contract does. So we all agree that these things need to go in: name of parties, effective date, blah, blah, blah. And what about this bit about intellectual property? Are you going to own it? Are we going to own it? Are we both going to own it? And then we're talking about principles. And we're allowing space for ourselves as lawyers to add real value to the business, because we're able to advise the business strategically as to what that actually means, rather than going, oh, now I'm going to negotiate this principle within the document. That's what usually happens, isn't it? You go in, you're like, well, hello, business person, do you agree that they should own all the IP? And they say, no, of course not. So, well, that's what the contract says. Well, push back. And then all of a sudden you're pushing back on a point that's not actually legal. This is a business point, right?
Exactly. No one's ever questioning whether or not using words, and it goes back to your point about Roman times and how things have developed. Like, no one's ever questioned whether or not it makes sense to represent obligations in words. Like, that's just how it develops. You know, but for business people, they get contract and they're like, whatever, here you go, legal, let's go. And you're like, okay, well, have you agreed to these SLAs? Is this the price that price you've agreed to?
Yeah.
You know, they don't engage with it because it's not in a way that they can understand, because it's all written in different ways. If we had a function-led contract and it was all function, we said, okay, well, this is this, it's always the same.
Yeah.
Even represented in a slightly different way, I don't know, some sort of, you know, icons and stuff, that's very, very basic, but so that they can understand it and engage with it, rather than legal having to go back to them. Do you agree with this? Oh, actually, there's this other point. It's just ridiculous. It's so inefficient.
So inefficient. It's so inefficient that you get a contract to review it, and it's almost like you're past this special document that's written in this special language that only you understand. You pick up the document and you start translating it, and you say to the business person, "Did you agree to this?" And they're like, "No, I didn't know that was in there." Well, of course you didn't, because you're not a lawyer, so you can't read this language. And this goes beyond legal design. This is about reimagining the way that we construct contracts.
Yeah.
Instead of taking words and using words that are very flexible, they're too flexible, right? You're using words to express certain things that are always expressed in contractual agreements, but each time it's in a different way. What if we just all agreed to agree to a load of modules or clauses that did a specific thing, bit like what we're doing with the oneNDA, but broader. And then we said, okay, let's just say that all these will be like Lego blocks that we use to stack on top of each other to create agreements. And those Lego blocks are expressed in such a simple way that instead of businesses leaving it up to the lawyers to negotiate the best legal position, which is, by the way, almost never legal, it's commercial, and that there's a difference. Why don't we all just get into a room and agree what we're going to put into the contract in a collaborative way? And that might sound very utopian, but why can't we do that?
I want to hear what everyone else thinks about this as well. So please add comments. We can discuss them afterwards. So let's talk about oneNDA and how we did that, because that was very interesting. Bit of an experiment. So please explain.
Well,
regale us with the tale.
It wasn't just an experiment. It was also the inspiration for this.
Yeah.
For this webinar. So what happened was that the way we approached it was very consensus led. It was not at all adversarial. So initially we were thinking, we had the idea, let's just have oneNDA, right? Does everyone think this is sensible? Yeah, so we set up a website. Within 12 hours, we had 100 people sign up to express interest in participating in the project. Today we've got over 1,000 organizations, and we now have a oneNDA that's not perfect, but it's out for consultation. We've now received feedback, and we've given it back to the steering committee, who are going to review it and agree what goes into it. And effectively, the way we approached it was, well, we were initially having loads of conversations about how do we do this? Do we get an NDA that we think is good, and we put it to everybody? And we thought, can you imagine 50 lawyers redlining an NDA?
Yeah.
Best of luck getting anywhere. So we thought, no, what we need to do is abstract complexity and talk about principles. If we don't worry about wording, because for some reason, I think I know the reason, but when you look at wording, you immediately feel like you either identify with the wording or you don't. And that might sound extreme, but you look at a clause, especially if you're a lawyer with years of experience, you'll look at a clause and you'll think, this is balanced, this is not balanced, this doesn't have enough detail, it's got too much detail. So you have this preference as to wording. And so we thought, let's get rid of that barrier. And let's just talk about principles. So we took an NDA that was given to us by the World of Commerce and Contracting, and this was an NDA that was created after they'd used AI and NLP to analyze 2,000 NDAs and come up with the NDA that would be the biggest sort of crowd pleaser. What's the NDA that everybody would just agree to because it contains everything? This was a 6-page NDA. It was really well written. It was quite simply written, but it was very long, and it included lots of clauses that we don't think are necessary. Also, just because this person likes them doesn't mean they should be in a universal NDA. So what we did was we took that NDA and we broke them out into 57 functions. So what does this NDA actually do? Not what does it say with words, what does it do? What are those functions? We broke them out into little cards that we put onto Trello, and then we got the steering committee to break up into 4 or 5 people and discuss whether they agreed these functions should make their way into the one NDA. And we ended up with 24 out of the 57 functions, so they'd actually culled 60%. And when we looked at, so we actually counted the votes to make sure that everything was transparent, but also we were interested to see how much people agreed with each other.
Yeah.
And it was so high. It was about 80% consensus in a lot of the clauses. We had some that were about 50-50.
Yeah, and people were so brutal with, like, you know, within the group. We gave them obviously a time limit, but people were just like cutting stuff and agreeing so quickly, which never happens in a negotiation.
Yeah.
It's like, oh, can I allow that? Can I not? People are like, whatever, get rid.
Yeah, get rid, because they're looking at the principle without being bogged down by the detail. And if you think of the human mind, that's how we work. The way contracts operate are just not conducive to the way the human mind works. You don't want to see a million. It's like when you go to a restaurant and there's like 3-page menu this big with tiny writing, like, oh my God, just give me 3 things. Let me choose from those 3 things, because you get overwhelmed. And when you're reviewing a contract, it's natural that you will be overwhelmed by the detail. So let's put aside the fact that you're human and you're bound to make mistakes, whether we like to admit it or not, because that's just too much info, and you've got an hour or 2 to review this contract, especially if you're in-house. You're reviewing this agreement, and there's like millions of words, and they're all hitting you, and you're like, oh, am I gauging the risk here? It's just so... But reviewing contracts is the perfect combo of boring and stressful at the same time.
And you forget why you're doing it when you're like knee deep in a contract. You're sort of like, what am I even looking out for anymore? I'm now just been doing this for like 3 hours. And sort of like, what?
What is that?
Need a rest.
Is it an academic exercise? Am I actually gauging risk? And it's just this conflicting. It's unpleasant.
Yeah, and that's the fundamental problem with contracting as an in-house lawyer. It's like, what is my role here? Am I here to protect the business from risk? And what's the risk tolerance? I need to go and find that out and reflect that in this contract. Or is it about allowing them to do what they want to do from an operational perspective? And there's always that tension. And sometimes people just take it too far because they do take this artisanal approach, and they just a misunderstanding of an in-house role. And you get that a lot more in private practice, I think, where it's sort of like, we need to get rid of every single risk. And is that the point of what a contract is? No,
that's not. That's not. But the problem with contracts is that they're so dense and detailed and difficult that you can't get anyone else involved unless they're a lawyer. You can to an extent, but in order to do that, you need to spend a lot of time abstracting that complexity and feeding it back. Whereas if we started from a position where the complexity had been abstracted and we'd all agreed to a standard wording that reflected that function, then it would just be so much easier to do our jobs. It would be so much quicker to get contracts through the door, because a bit like Agile, where you all get into a room and you just agree that these are your priorities and you have your stand-ups every day. You could do that with your contract, right? You could also iteratively build the contract as the commercial agreement was forming, so that you could form part of it. Or at least if you can't form part of it, at the end of the process, it's really easy to get all the commercial people in the room and say, right, this is the menu of clauses that we would normally see in an MSA. These here we need, so let's not discuss. These here are about the IP clause. What do you guys think? Is Is it option A, where we all own our own IP? Is it option B, where you own it all? Or is it option C, where we own it all? That's quite a simplistic way to look at it, but that's just to illustrate that that could be the conversation that we could have. And then as soon as agreement is made as to what goes into the agreement, as to what the commercial parties agree to, then your contract is really quickly created, and you're not worrying about tweaking all the wording of every single clause. And of course, not all standardization is going to be suitable. Not all standardized wording is going to be suitable, but to a large extent, you've got rid of so much inefficiency.
Yeah, and you're just focusing on the bits that are complex, where you need a lawyer to actually sort of interpret or, you know, negotiate the bits that are legal.
Yeah.
But as you say, like the majority of points in the commercial contract are not, they're called a commercial contract for a reason, they're commercial points.
Yeah.
Okay, so to get to this point, we need to standardize.
Yeah.
Is the outcome. So how do we do that? I mean, we've done it with oneNDA.
Yeah.
Almost.
Yeah.
How do you get there as an industry? And obviously it's not suitable for everything. It can't be.
Yeah. I think that we can't expect to have one body that goes, here's a good clause, accept this, because that doesn't work with the legal psyche. I think it needs to be a group effort. So a bit like what we did with oneNDA, but at scale. So if we imagine a world where we're all crowdsourcing standards in an open source environment, so that they're not hoarded by private enterprises that then just, you know, then that's how you create loads of conflict of interest and you don't really reach true efficiency. If we were to democratize it, open source it, and use the legal community to create these standards, I think that's how we get to a world where contracts are viewed differently. I think number one is mindset, though, because lawyers often think that their job is too difficult to commoditize or to standardize. But is it?
I mean, to an extent, it is at the moment. Well, in the absence of standardization and in the absence of people agreeing on those sort of standard points, then a lot of it is, because you could commoditize, like you could if the contract itself were different.
Yeah.
But at the moment, it's not easy to commoditize that. I think, in this ideal utopian world, which actually isn't that far off if we continue on this vein. But at the moment, yes. Because if you get an IP clause and you've never seen that, even as a lawyer, sometimes you're like, what is that saying?
Yeah, I know.
That's not possible to commoditize at the moment.
No, but the severance clause.
Oh.
How many severance clauses can one read? I mean, they all say the same thing, don't they?
The parties, like so much boilerplate.
Entire agreement.
Yeah.
Let's just agree. Entire agreement means this, and then just crack on.
Get over it.
It's not.
We
that
get
difficult.
it. Okay. Yeah.
It's
everything's
not that difficult. Yeah. It's not that difficult.
No, it's not.
Our job isn't that special for everything. It's really special when it comes to the things that are very complex and you need a legal mind to navigate through the risks and issues and potential results and outcomes, and then they can advise the business because they know the business and their risk appetite. And that's the interesting, meaty stuff that you want to be doing. What you don't want to be doing is trawling through word for word in each agreement, wordsmithing and making sure that that reflects what you want it to reflect, but also your preference. I mean,
yeah, and it goes back to the stuff that we've talked about before in previous webinars about what's your core and what's your non-core as a legal team, because actually the core work is the real strategic stuff where you're adding real value, where you're talking to the CEO and saying, look, these are the risks of doing X, Y, and Z. Like that's where having a legal mind and a legally trained brain is super helpful, because you are cognizant of risks and are able to sort of weigh things like that. That's what our training is for, and that's where we can add real value. But this non-core stuff, reading another entire agreement clause, like no, it's a waste. You're so expensive as resources. It's a waste of money for the business to be paying that.
But also, you're so capable, and you can add so much value. But you've never got time to do that because you're bogged down by. I'm sorry to say, but a lot of times admin. Yeah. And you know, I think the argument that I've had before from some people that have heard us talk about this topic is, well, are we just going to do junior lawyers out of a job? Yeah. What do you think of that?
Well, no, I don't think. Obviously, they'll just get to do more interesting, exciting stuff, because at the moment, a junior lawyer's job is often reviewing NDAs, maybe doing some sort of paralegal contract database admin, let technology take care of that bit, and they can actually add strategic value at an earlier stage. And I think what's really interesting about the industry at the moment is that we are seeing a rise and rise in in-house lawyers, and that's why there's this push for efficiency, because there hasn't been an incentive to be efficient previously, really, because it's all done in private practice. But there's more and more people who are in-house. They're stretched. They're working in companies that are scaling so quickly, and the pace of the legal team growing is obviously not at the pace of the business. So they need to find these efficiencies.
Yeah.
And actually, they could do with their junior lawyers not reviewing so many NDAs. They need them to help with the meatier stuff.
Yeah, exactly. Absolutely. And the other thing, that's a really interesting point. The other thing, and the reason why we're seeing this rise, I think, is because in private practice, you can do an amazing job, but you're never really part of a business.
Yeah.
And so you're doing this amazing legal working, like that opinion I wrote was just absolutely banging. I'm going to send this out right now. It's going to be amazing. And then the business looks at the opinion like, oh, this is so long. I haven't got time. Also, okay, what are the risks? Right, cool. And then you move on. So when you're in house, you're the consumer of the services of the private practice lawyer. So you're on the other side, and you've got this visibility, and you're like, wow, okay, so what I did really I thought was amazing.
I know,
but actually it hasn't got the value that I thought it had.
I know, and it's a shame. But it's like, you know, I think it's enabling private practice people to innovate a bit more. But I think it's really exciting that we've got lots of in-house people who are excited in this sort of stuff as well, because, like, I don't know, I just feel like there's this real in-house revolution at the moment, and everyone's super passionate about this stuff, and it's great to have people coming to webinars like this today. Yeah. I wish that we could actually chat with people.
I know. We'll do it. We've said it before. We should do it next time so that it's a proper thing. Has anyone got questions, comments,
anything?
No? Yes, you must do. Yes, got our first question. Oh. So Amanda says, this is fantastic, so refreshing. Instead of innovating, in-house teams want to keep adding headcount because their lawyers are swamped in stuff that doesn't add value. Yeah.
Exactly.
And
then you just look annoying because you go to the CFO and say, oh, we need another person now. And they're like, what? What for? And it's hard to even demonstrate what you need it for. Just this volume of crap that you have to wade through.
Yeah. Exactly. And, you know, lawyers aren't just, in-house lawyers aren't really thinking about innovating as such. They're just thinking about how to do this in the most sensible way. And often innovation is confused with technology, but actually innovation, I think, is taking a collaborative approach to standardize so that we can just work in a better way.
Yeah, it's sort of taking a ground up approach rather than just applying stuff on top of technology, on top of all this broken stuff. You know, let's sort out the bottom, let's sort out the foundations. Right, Asim says, interesting discussion. Given that most people use PLC templates, which are drafted by a selection of lawyers across different firms and industries, and there is little consensus in use of these templates, with parties still intent on adding their own flavour to the template. Absolutely. I mean, the number of times I've pulled a template off PLC and had to stop adjusting it because no one wants it to look like it's PLC. PLC's NDA template is a perfect example of this. Do you think lawyers just have a natural urge to amend, and this is not something that we can really change? Interesting question.
Yes. I think they do have an urge. They do have an urge to amend. You want to add value. Also, you know, you've seen other ways of doing it that you think are better, but it's about trading off your preference for efficiency. Because is your preference really going to add value? Is the moving of that word to this bit to make it clearer really going to add value? And that's the question that we keep needing to ask ourselves. And with the oneNDA, we always say to people, when we ask them for their input, okay, cool, but are you going to get sued over this? Are you really opening yourself up to additional risk over this? Or is this your preference? Is this stylistic?
Yeah.
Or is this a true risk that you foresee? And if so, please tell us what it is. And often you'll find that people don't actually perceive a risk. What they're after is a comfort blanket. And that's very different. So it's about us being realistic around, you know, is this going to add value, or is it just me seeking comfort? And if it's the latter, don't bother, because your seeking of comfort will create such an inefficiency that the value to effort ratio is disproportionate.
Totally.
Yeah.
And I mean, that comfort blanket goes into, pulling a template off PLC and making it look like it's not from PLC. So
Yeah.
look like,
Oh yeah, I know. Especially at the beginning when you pull it off PLC, and I think, oh gosh, people are going to think
people are going to know I'm going to be rumbled.
Yeah, I'm going to be rumbled. People are going to think that I'm not a real lawyer. Like, no lawyer has ever drafted anything from a full agreement from scratch.
No way.
Ever got time. Thanks, Nina.
Thanks, Nina. Tim says, the way I think about commenting on drafting, would I be prepared or embarrassed to defend it on a call? Exactly.
That's a really good
one. That is a good point. And that happens. And you're like, oh, God.
Actually, that's fine. Yeah.
And it's so embarrassing.
It's so embarrassing. You look pedantic.
Yeah.
And pernickety.
Yes.
And it's just not a cool look.
It's not. Anything else?
Any other questions, thoughts? What do you think? Do you think we're being overly optimistic? Do you think we're being naive? What do you think?
Yes.
Is this possible? Would you use a library of open source standardized clauses to design your agreements rather than negotiate? How do you see that practice? I'm really genuinely interested to hear what you think. So Amanda's saying the issue with the painful to and fro on contracts is often lawyers can't see the wood for the trees. I completely agree with you both, and I could talk about this. Great,
Amanda,
you're coming out. Rob, what are your thoughts on customers having their own standard contracts at all? Might it make more sense to work from suppliers' terms at all times that have been drafted specifically for the product or service, than update such terms as necessary, perhaps with a standard contract addendum or key clauses that can be appended to suppliers' terms? Yeah,
I find it really difficult where you're working with a big corporate and you're the supplier. And I've done this when you're working, and then they send you their suppliers' terms, and you're like, but we're giving you this product.
Yeah.
I find that really difficult because you're like, then you have to spend so long amending the big corporate's terms to make sure that they fit your product, but you're buying my product.
Yeah. But what if we had, say, for example, this has happened to me with a master services agreement where I was working for a consultancy. It was a design agency, and they were consulting to a big bank, and the big bank sent them their MSA. Yeah. And I had to spend ages just tailoring it so that it fit the service. And then in the end, the bank said, sorry, we're not accepting any of your changes. And we had to say, okay, because you're a bank and we really want to work with you. So here you go. We all know this is not fit for purpose, but we'll just make it work on the ground,
right?
Which is really not the purpose of the contract, and what a waste of their money on me. But ultimately, I think that what if we all just agree to one MSA, for example, and then if you're a supplier, then you can have your specific term. So that's what, Rob, you're saying. I think that would be a really good starting point, because you're not having to negotiate all that boilerplate language or even read it and go through it. You're just negotiating that bit that's relevant to you. And then the bank could have said, okay, I see how these apply because of the nature of the service, and we're happy to incorporate it into this agreement.
Yeah. The only downside I can see with this approach, and I've heard about this, is, you have standard terms and then someone just applies a rider.
Yeah.
That basically just invalidates all of the, cool, thanks for your terms, but here's this rider that is just our terms. So you end up with this weird, I've seen that happen. And I don't totally know how you get around that, but unless it's like an ISDA menu, I don't know.
Yeah. An ISDA type.
Yeah.
An ISDA type situation would work, I think. And also it just goes back to us really understanding the value of standardization. You don't need to have legal perfection every turn of the way. It's not like your MSA is the best MSA for you ever that doesn't give you any risk. Of course it does, because there is no such thing as perfection, because law's not black and white.
Yeah.
So if you can appreciate that and realize that the standardization piece has bigger value than you having all your potential risks that you imagine covered, then you can get to a place where you can agree to standard MSAs, and then you can just have a tailored one-pager on the side.
Yeah.
And that one-pager doesn't necessarily even need to be tailored language. It can also be pulled from a clause of libraries.
Yeah, yeah.
And that's, I think, the ideal.
Yeah, we'll prefer the latter.
Yeah,
definitely.
The latter. Cool. A couple more. Jeff. Standard templates and clause banks are a good idea, but we need a culture change as well, which I hope we are beginning to see. For example, I'm currently looking at a contract based on a set of logic, oil and gas industry, standard terms, where the specials are half as long again as the standard terms. Yes. Yeah. See, that happens. But Jeff, if we did have a clauses library that you could pull in to reflect the terms that the person put onto that special, onto the specials, that would also be easier. But I totally agree that the first thing that we need is a culture change and a realization that when the things that we do aren't that unique. And the World Commerce and Contracting, Sally, who was on one of these webinars a couple of months ago, she said that around 90% of agreements contain more or less the same stuff, but just expressed in different language. If we were to get rid of that 90% and replace it with standardized terms, and we just say we did have a bit of artisanal language that was needed to reflect something really, really nuanced, I'm sure that's always going to be required. But we need to raise the bar of what's nuanced and what's actually commoditizable, and almost get over ourselves as lawyers. We don't need everything to be bespoke and special. We can still get the job done properly if we use standards.
So that goes to Asim's next point, which is yes, I think.
Yeah.
No, depends on. So aren't you effectively asking lawyers to make themselves redundant in the future? Turkeys voting for Christmas. It depends, really. It depends on what you like doing as a lawyer. But I think, we're maybe taking ourselves out of the really crap bits of contracting, but we'll still be negotiating the really key points and actually what needs to go into that contract and advising the business strategically on which functions need to go in. You're not just spending all your time actually redlining it to make sure you'll be doing more deals. You'll be getting through them quicker.
Yeah.
So
also, haven't you had a situation where you go into a negotiation with the other side and you start talking about the principle, like, hello, we're going to own the IP, and then the conversation moves from that to, but what about this wording here? So there's this dual conversation that's happening that's confusing the main purpose of the conversation in the first place. You still need to negotiate. You still need to advise the business. Asim, what you're saying is like saying to accountants 20 years ago, is Excel going to do you out of a job? No, it's just doing you out of having to use an abacus. No, I think after that, a calculator
in the 60s. Abacus.
Yeah. To do your job. The answer is no. Excel just made your job faster and less annoying and more productive. So, in summary, no. Sarah? Sarah saw an approach several years ago from GC at Scottish and Newcastle breweries, which tried to reduce contracts to the absolute minimum, price dates, product supply details, and IP, and rely on the common law for the rest. Never got very far, but was certainly of interest at the time to an in-house audience.
Interesting. So I can't imagine people getting very comfortable with that.
No.
How did that go? Because I think lots of people, interestingly, when we did the oneNDA, they said, well, we don't need this because you have the common law duty of confidence, so whatever. But then there's lots of these questions of, okay, well, how does that work from a cross-jurisdictional perspective? And I think maybe lawyers are so risk-averse that, I wouldn't back myself to know
what the common law is.
The common law, what if there's an updated case, what happened? Yeah.
But also I think that contracts aren't just there as legal instruments. Contracts are actually very behavioral. It's like, especially with the NDA, when you sign an NDA, you may not even need an NDA because you're talking about stuff that's in the public domain, right? But you still sign an NDA. And the reason you sign an NDA is twofold. It creates this, it's like a debt. I've gone to the effort of creating this NDA to show you my appreciation. So it's almost like a token of, there's an exchange that happens, which is at a relationship human level, really, really important. I'm giving you something, I'm creating debt because I'm using my resource to give you this so that you know that I'm serious, yeah? So that's the first thing. The second thing is that it just provides comfort to people who want to use contracts as that safety blanket and that creation of the right behaviors from the outset. Like, guys, we've already said this, we've set expectations. We're not going to tell other people about this secret stuff that we're talking about, okay? Okay, cool. That's all human psychology more than law. And I think that's really important to maintain to an extent until we're perhaps ready to move away from it if that ever happens. But I think contracts are important. It's just the way that we do them are terrible.
I'm sorry if you can't hear very well because it's raining, but I think Tim is agreeing with you essentially there, Electra. So contracts normatively ought to aid certainty and usability for non-lawyers, and common law does gradually evolve. So I agree, like in terms of from a behavioural perspective, you kind of want to have a contract not just to drive the right behaviours, but so that non-lawyers can look at it and be like, okay, this is what I'm meant to be doing. Not that they ever do because they're written in such a ridiculous way, but that's the idea.
Yeah. Sarah's saying the idea that whilst the relationship was working, not a lot was needed other than a base framework. If it all went wrong, both parties were likely to just want to get out of the agreement ASAP with a minimum of fuss. That makes so much sense, doesn't it? Just to say, okay, cool, you know, if we need to terminate, we're just going to walk away. We're never going to go to court over this.
Well, exactly.
I just want out. So yeah, it does depend on the nature of the relationship as well. In some instances, that might be perfectly suitable. I think in probably the majority of commercial interactions, you might need a contract, but yeah. Anything else? We're gonna try and end this in 3 minutes, as to give everyone 15 minutes back. Any more questions, thoughts? No? That was fun. Favorite topic?
We'll have to do it as a actual meeting next time.
Yeah, in real life.
Oh yeah, maybe. Be fun.
The last one we had at IRL was February 2020.
Yeah. Oh yeah.
That was fun.
That was fun.
We'll do it again. All right, everyone. We're going to let you go. Thank you so much for joining.
Thank you.
Thanks for your comments. And if you've had any thoughts about this and didn't want to express them publicly, feel free to email us. See you soon.
Bye, guys.
Bye.